So you're prepping for an exam, or maybe you just really need to get a handle on the rights of an unpaid seller. Well, you've come to the right place. We're going to break down every single key concept step by step to give you a really clear and confident grasp of this crucial area of commercial law. By the end of this, you won't just know what the rights are, you'll get why they exist and how they actually work in the real world. Let's get right into it. First up, we're going to define our main character, the unpaid seller. Then we'll get into their legal toolkit, the powers they have, starting with the right of lien and the right of stoppage in transit. After that, we'll put those two rights head to head to see exactly how they're different, which, by the way, is a classic exam topic. From there, we'll look at the seller's ultimate power move, the right of resale. And we'll finish up by exploring some of those tricky special cases and exceptions you've got to know. It all builds logically, one piece at a time. All right, first things first. Before we can even talk about rights, we have to figure out who legally qualifies as an unpaid seller. This definition, it's right there in Section 45 of the Sale of Goods Act, and it's the absolute foundation for everything else we're going to cover today. If a seller doesn't meet this specific criteria, well, then they don't get any of these special rights. Simple as that. So the law gives us two really clear scenarios here. Part A is the obvious one, right? The full price just hasn't been paid. But Part B is a little more interesting. It's all about payments that come with a condition. Imagine the buyer pays with a check. That payment is only good if the check actually clears. If that check bounces or if some other kind of payment, like a bill of exchange, is dishonored, then that condition for payment hasn't been met. And in that instant, the seller goes right back to being officially unpaid and can start using their rights. And there are a couple of crucial details to remember here. First, the amount owed doesn't really matter. I mean, if a buyer pays for 99.9% of a huge shipment but is short by even a tiny amount, the seller legally qualifies as unpaid for the whole thing. The law isn't concerned with the size of the debt, just that it exists. And second, the seller has to play fair. If the buyer is ready with the money, they tender the payment, and the seller wrongly refuses to take it, they actually lose their unpaid status and all the special rights that come with it. This flowchart is basically our roadmap for this whole topic. It shows the path we're about to take. Now, notice that critical split right at the top. Has the property and the goods, meaning the ownership, passed to the buyer or not? The answer to that one question decides which set of rights the seller has. We're going to focus on that left branch first, the scenario where the buyer is technically the legal owner, but the seller still hasn't been paid. This is where the big three rights come into play: lien, stoppage in transit, and resale. Now for our first major right, the right of lien. If you remember just one word for lien, make it possession. Seriously, this right is all about the power to physically hold on to the goods. It's the most basic right an unpaid seller has, and it all comes down to who has the goods in their hands.
The key here, and I can't stress this enough, is physical possession. To use a lien, the seller must still have the goods. It's the right to keep what you already have. Think of it like this. If you don't pay the bill for your car repair, the mechanic can legally keep your car until you pay up. They're exercising a lien. As soon as those goods are on a truck and out of the seller's control, it's too late for a lien. The seller is, for all intents and purposes, legally holding the goods hostage until they get paid.
So the law is super specific about when this right can be used. First, in a normal cash sale where there's no mention of credit, payment is due on delivery. The seller can hold the goods until they get the money. Second, if goods were sold on credit, say net 30 days, the seller can't use a lien during that 30-day window. But the second day 31 hits and there's no payment, that lien becomes active. And the third one, this one's a real game changer. If the buyer becomes insolvent. If that happens, the seller can slap on a lien immediately, even if the credit period isn't over yet. The law protects sellers from having to ship goods to a buyer who they know can't pay. This example just nails that third point perfectly. So A gives B a month of credit. Normally, A would have to send the goods and just hope for payment, but because B becomes insolvent during that credit period, the whole game changes. Insolvency acts as an immediate deal breaker. A no longer has to send off the goods and then get in line with all the other creditors, hoping to get pennies on the dollar. Nope, they can immediately use their right of lien and just hold on to those goods. Okay, let's break down the rules of the road here. First, as we've said, possession is king. No possession, no lien. Second, the lien is only for the price of the goods. It doesn't cover extra stuff like storage costs or late fees. Those have to be claimed separately. Third, if part of an order has been shipped out, the seller can still use a lien on whatever is left. And finally, here's a fascinating little technicality. Even if ownership has officially passed to the buyer, As long as the seller physically has the goods, they can still use their lien. They might be holding them as the buyer's agent, but their status as an unpaid seller trumps that. So this is a pretty powerful right, but it's not forever. How can a seller lose it? Well, there are 4 main ways. First and foremost, when the seller gives the goods to a carrier, like a shipping company, to send to the buyer. The moment they give up possession, that lien is gone. Second, obviously, when the buyer or their agent legally gets their hands on the goods. Third, by waiver. The seller can just say, I waive my lien, or they can do something that implies it, like offering new credit terms. And fourth, like we said before, if the buyer shows up with the money and the seller refuses it, the right is terminated. Okay, so what happens if the seller has already lost possession? What if the goods are on a truck halfway across the country and then the seller finds out the buyer just went bankrupt? The right of lien is off the table. Is the seller just out of luck? Not quite. This is where our second major right swoops in, the right of stoppage in transit. This is all about reclaiming goods that are already on the move. Now, the definition here points out 2 absolutely non-negotiable conditions. First, the buyer must be insolvent. This right isn't just for a late payment. It's a very specific and powerful tool for insolvency. If the buyer is just a little late but still solvent, you can't use this. Second, the goods have to be in transit, which means they're in the hands of a carrier somewhere between the seller and the buyer. This right is all about regaining possession you've already lost. You can think of it as an extension of the right of lien. Think of this as a checklist. For a seller to legally tell a shipping company to stop a delivery, every single one of these boxes has to be ticked. The seller must be unpaid. Check. They must have already shipped the goods. Check. The goods have to be currently in transit. Check. The buyer has to be insolvent. Big check. And just like a lien, this right is only for securing the price of the goods themselves, not any other fees. If even one of these isn't met, the seller can't legally stop that shipment. This whole concept of duration of transit is so important because the second that transit ends, the right of stoppage just disappears. Poof. So when is transit over? Well, it can end if the buyer intercepts the shipment early. More often, though, it ends once the goods get to their destination and the carrier tells the buyer, hey, your stuff is here, we're holding it for you now. At that moment, the carrier stops being a neutral middleman and becomes the buyer's agent. And at that point, transit is legally over. All right. We've covered lien and stoppage. Now let's put them side by side. Nailing the difference between these two is absolutely critical, especially if you're studying for an exam. This comparison right here is one of the most important things to take away from this whole topic, so let's break it down really carefully. This table just lays it all out perfectly. Let's walk through it. First, possession. For a lien, the seller has the goods in their warehouse. For stoppage, the goods are on a truck somewhere. Second, insolvency. This is the big one. A lien can be used for any late payment after credit expires, but stoppage can only be used if the buyer is insolvent. Third, timing. They're like a relay race. The right of lien ends the exact moment the right of stoppage begins. The second the seller hands the goods to the carrier, lien is over, but the window for stoppage opens. And finally, the nature of the right just sums it all up. Lien is a right to retain what you have, while stoppage is a right to regain what you've lost. Okay, so this seller has either used a lien to hold onto the goods or they've successfully used stoppage to get them back. So now what? Just having the goods sitting there doesn't get them paid. And that's where the third and maybe the most practical right of all comes in, the right of resale. This is the seller's way to finally cut their losses and recover their money by just selling the goods to somebody else. Now, a seller can't just immediately turn around and resell the goods. They need a legal reason. The first one is a no-brainer. If the goods are perishable, like fresh fish or flowers, the law lets them resale quickly to avoid a total loss. The second is if it was written right into the original contract, a clause that says, if you default, I can resell. And the third, which is the most common situation, is when the seller gives the original buyer a formal notice saying, hey, I'm planning to resell these. If the buyer still doesn't pay up in a reasonable time after getting that notice, the seller is good to go. Giving that notice isn't just a courtesy. It has massive legal consequences. If the seller gives proper notice and then has to resell the goods for less money, they can sue the first buyer for that difference, for the damages. But, and this is key, if they resell without giving notice, they lose the right to claim those damages. The notice also gives the buyer one last chance to fix things. It's a final warning shot that allows them to pay up and avoid a bigger financial hit. Okay, for our final section, let's look at some more advanced scenarios that can really complicate things.
What happens when the buyer tries to sell the goods to someone else before the original seller has even been paid? Can the unpaid seller's rights be wiped out? Well, the general rule is no, but there are two really big exceptions to that rule.
So on the left, we have seller's assent. If the original seller knows about the subsale and agrees to it, they've basically waived their rights. They can't okay a sale to a new person and then try to stop the goods from getting to them. Now, on the right is a more technical but super important point, the transfer of a document of title. Think of something like a bill of lading for an ocean shipment as the legal deed to those goods while they're at sea. If the original buyer sells the goods to a new innocent buyer and transfers that official document to them, the rights of that new buyer can actually defeat the original seller's right of stoppage. The law steps in to protect that innocent third party. Hey, remember that roadmap from the very beginning? We've spent all this time on the branch where ownership has passed to the buyer. But what if it hasn't? What if the contract says ownership only transfers when the final payment is made? Well, in that case, things are a lot simpler for the unpaid seller. They have the right to withhold delivery. Since they still legally own the goods, they can just refuse to deliver them. It's basically the same outcome as a lien or stoppage, but it comes from a much stronger position, since they're still the legal owner.
And that brings us to the end of our deep dive. We've defined the unpaid seller, we've unpacked their core rights of lien, stoppage, and resale, and we've even looked at the key exceptions. But let's finish with a final thought. These laws were written in an age of ships and trains, so it makes you wonder, how do these fundamental ideas about possession, transit, and insolvency apply today, in an age of drop shipping, where a seller in one country might never even touch the goods being sent from a second country to a buyer in a third? It's a fascinating challenge that shows how these old legal ideas are both timeless and constantly being tested. Thanks for joining me for this explainer.